Be now put.
Honourable David Cunliffe. Thank you, Mr. Chairman.
Mr. Chairman, I rise to address Part 1 of the Government Communications Security Bureau Bill. In doing so, I'm going to speak from first principles and speak to the grave and fundamental constitutional and privacy concerns that are surrounding this bill. Let us restate at the outset that Labor will immediately set up a cross-party inquiry to thoroughly and independently review the effects of this bill, if it yet passes, on our security agencies and on the rule of law. Mr. Speaker, following that review, we will repeal the bill in its current form and replace it with new provisions that get the balance right between privacy, constitutionality and the rule of law. Mr. Chairman, before taking calls to detail exactly what is wrong with the drafting of the bill and how it must change, let me first state several issues which the bill is not about. Firstly, sir, it is not about Fonterra, although it is intriguing that Friday's 4:30 p.m. dump of sensitive stolen emails that implicates the Chief Executive of the Department of Prime Minister and Cabinet and the Prime Minister's Chief of Staff occurred shortly after the government was notified at around 12:30 that day of Fonterra's imminent disclosure. Mr. Chairman, it takes something akin to botulism to make this bill appear mildly palatable to some. Mr. Chairman, secondly, this bill is not specifically about the details of the Peter Dunn-Andrea Vance email trail. However, the broad context is relevant. Let the House and the public of New Zealand recall that those stolen emails related to an inquiry into a leaked document. The document was the Kitteridge Report, the damning litany of the legal and oversight failures of the very same Government Communications Security Bureau. The Kitteridge Report was prompted by the fiasco that was the illegal spying on Kim.com. And it transpires that Mr. .com was one of at least 88 New Zealand citizens upon whom illegal spying operations have been conducted. And Mr. Chairman, for all we know, on that list of 88 might well be current or former members of this House. Mr. Chairman, let us be absolutely clear. The appropriate response to spies running amok, illegally spying on New Zealand citizens, is not simply to legalise it. Mr. Speaker, as others have said, the response to illegal speeding is not to raise the speed limit, and the proper response to theft is not to legalise stealing. The proper response to illegal spying is not simply to legalise the practices that were hitherto illegal. Mr. Speaker, and this is important, thirdly, this debate is not about removing from New Zealand the capability to defend ourselves against foreign cyber attack. New Zealand needs to have those capabilities and must be equipped to perform them well. But, and it is a huge but, those capabilities should not be deployed against our own citizens except in the most unusual and exceptional and verifiable circumstances, and only then, with a judge's warrant based upon an independent and thoroughly, substantially evidenced threshold of proof. Mr. Speaker, the warrant process must protect our citizens from arbitrary mass surveillance, whether performed directly by the New Zealand GCSB or indirectly by the access of information sourced from other partner countries' agencies. Mr. Chairman, this bill is about crafting rules that achieve, or should be about, crafting rules that achieve a proper constitutional framework for activities which may be necessary in exceptional circumstances, but which must never become routine. And the definitions of information infrastructure in Part 1 of this bill, Mr. Chairman, which include, and I quote, all emissions, all communications transmitted across all networks. Mr. Chairman, Mr. Chairman, Mr. Chairman,
Catherine Delahunty.
Mr. Chairman, Mr. Chairman.
I'm calling Catherine
Mr.
Delahunty.
Chairman.
Thank you, Mr. Chair.